Well, thank you, Governor. It's been a privilege for me to serve on the Constitution Project's Death Penalty Committee, and as Governor White has said, I want to thank all of the folks on the committee that have done such tremendous work, and also the staff, President Jenny Sloan and Sarah Tuberville, who's a senior counsel, Nikki Sprinson, who's here with Aiken and Gump, who's done so much work, and the firm has offered their facility for more than this meeting, so we're really grateful. So it's a pleasure for me to join them, and Anthony Graves, who I'm going to introduce to you in a minute, whose story is really powerful. You know, I learned a long time ago that the way to illustrate sometimes complicated legal issues is to tell a story. And Anthony's going to tell you a story that I think sort of sums up why the Constitution Project's Death Penalty Committee has 39 recommendations for states across the United States to consider. So, Anthony, I really look forward to your comments in a few minutes. My comments will be brief. I just want to talk about 4 of the 39 recommendations that are coming from the committee. Just by way of background, I was in the Senate of Virginia for 10 years and then Attorney General of Virginia for 4, and then I ran for governor in 2001. I lost. I like to say I came in second, but it doesn't count in politics. But during the time I was in the Senate and Attorney General, I had a fairly, I think, cavalier approach to the death penalty. You know, conceptually it seemed right to me, and so I was a very strong advocate of the death penalty. As Attorney General, when we had 36 executions during the time, and it was only 3.5 years that I was there, it changed the way I looked at the death penalty. I looked at it a lot less conceptually, a lot less cavalierly, and I came to the conclusion that as someone who throughout my career had been a small government conservative, I wondered why I placed so much faith in the government to get perhaps the most ultimate decision any entity could make right. Now, why do we believe that the government can always get the death penalty right? And so we obviously know now that we can't. And the genesis for a lot of these reforms have been what we've seen throughout the United States over the last 2 decades in death penalty processes, and why we need to ensure that if we're going to have a death penalty, that it has to emphasize fairness and not expediency. So let me talk about 4 of the recommendations specifically. One is we need to have attorneys who represent defendants in death penalty cases to be experts at what they do. 50 years ago, last year, we had the Supreme Court case of Gideon versus Wainwright, which says that a defendant has a right to counsel. And we all know that people who are charged with a death penalty have the right to counsel. But if you're going to have heart surgery, you don't just want to write to a doctor. You want to write to a heart specialist who is well trained and is an expert in heart surgery. The same is true for the death penalty. You do not just want a lawyer. You do not just need a lawyer. You need someone who is well trained in death penalty defense. And it is a highly specialized area of the law, extremely complicated, infused today with so much science, so many procedural issues at the state and federal level. Many of our death penalty lawyers who take these cases and get appointed to them around the country are under-resourced, ill-equipped, and lack training. It shocks me now to look back, I don't know how many years ago, 1984, I was out of law school for 2 years. I was on the court-appointed list in Norfolk, Virginia, and was appointed to represent a young 22-year-old man who was charged with capital murder. At the time, I was privileged to have that opportunity. But that should have never happened. I didn't have any business handling a death penalty case because I had no experience in it, and yet this man's life was placed in my hands. It's another story how that turned out. I won't tell you it turned out fine, but not because of me. It turned out fine because I happened to know the lead homicide detective. He was a friend of the family. So we need to have well-equipped lawyers who represent death penalty defendants. States like Virginia, my home state, have made tremendous strides in this in the last few years in setting up a capital defender's office, well-trained investigators, well-trained lawyers, and most importantly, well-funded. It takes money to do this, and it has to be done at the state level. Texas, as Governor White said, has made a lot of strides. They have a specific public defender now, a specialized public defender for defendants in less populated counties where there's not that many lawyers. They have a statewide office of post-conviction review, which is vital. But what we're recommending in the report is that every state look at the level of competence of the lawyers that represent those in death penalty cases to set up an independent authority that can monitor, train, and resource these particular teams of men and women who do some of the most important legal work in the country. The second recommendation I want to talk about, and it's closely linked to the first, is that after the trial is over, if a defendant has had ineffective counsel, that the way that case is reviewed be changed. Right now, if you're able to prove that you had ineffective assistance of counsel that fell below a minimum level, that's not good enough. You then have to show that even though you had just a doctor and not a heart surgeon, that you would not have been found guilty. Well, that's a real high stair to climb. In this report, all of the committee and all of these recommendations are unanimous, suggest that the new standard be that if you show that you've had representation that falls below the minimum qualifications, the minimum standard of competency, that the burden then shifts to the state. It doesn't stay on you. It shifts to the state to show that the outcome would have been the same. The third recommendation I want to touch on briefly is that when there is a review of cases at the post-conviction level, and there almost always are, that the review be made on the merits of the case. Too often today, the judges never get to the merits of the case because the procedural issues trump them from getting there. I remember when I was Attorney General, almost on every appeal case, our biggest gun was that we're not even going to get to the merits, Judge, because the procedure wasn't followed. And if you win on that, then the judges don't get to see the merits. Right now in Florida, as example, 34 death row inmates will never have their cases reviewed under current law because their lawyers failed to file a review request required by federal law within a year. So it will never get to the merits because of a procedural issue. So we need to move these procedural issues out of the way a bit so it can get to the merits more, which at the end of the day is really, I think, what all Americans feel comfortable with. If they support the death penalty, they want to make sure it's based on the merits, not a technicality that keeps justice from being done. Finally, the last recommendation I'll touch on is the felony murder rule. The felony murder rule simply says if you're involved in a felony that results in a murder, even if you didn't pull the trigger or hit anybody, if you were part of the conspiracy or you drove the car or you pushed somebody down but you didn't intentionally mean them to be harmed, then you can be found guilty of murder. Well, in some cases, in some states, you can not only be found guilty of murder, but you can be found guilty of capital murder. If that's the case. There's an example in Tennessee, a fellow by the name of Carino Pruitt, just to show you how I think unjust this application of law can be. He and his friend decided to steal a car from a convenience store parking lot. Car's owner, a 79-year-old man, came out of the store. Pruitt pushed him to the ground and drove away. No firearms, no weapons were used in committing the robbery. The victim, at 79 years old, had serious health problems, including a bleeding disorder, and he later died in the hospital. When Pruitt learned of the death, he turned himself into police. Not only was he found guilty of second-degree murder by a jury, which means the jury found he didn't intentionally cause the victim's death, but because Tennessee has a felony murder rule, he was found guilty of felony murder and was given the death penalty. So in light of that, this report, Irreversible Error, suggests strongly that the felony murder rule not be applied in death penalty cases. So I've just touched on 4 of the 39 recommendations that are in the report. We all feel strongly about all of them. It was a pleasure to serve alongside of these folks. And again, this committee and this report is not about being for the death penalty or against the death penalty. It is about saying if there is going to be a death penalty, if we're going to allow the government to take a person's life because of a crime, the trial process should be fair, and it shouldn't be a rush to expediency. At this time, it's my pleasure to introduce to you Anthony Graves, and I've already told you a little bit more about him. I'm not going to tell you more because I want you to hear his story. Anthony, come on up.